Good morning, I'm Gretchen Ho. We're coming to you on this Friday, the 30th day of January, bringing you Morning Matters because your morning's matters get to the stories that matter today. The Supreme Court has officially rejected the bid to reopen impeachment proceedings against Vice President Sara Duterte. The unanimous decision upholds the voiding of the complaint, citing critical constitutional violations in the filing process. Rodrigo Duterte's defense has filed a notice of appeal challenging the ICC's ruling that declared him medically fit for trial. The camp argues that the court erred by disregarding private medical reports that detail the former president's cognitive impairment. And a recent Octa research survey reveals that nearly 8 in 10 Filipinos identified China as the country's greatest external threat. The data highlights a persistent and strong majority distrust toward Beijing amid ongoing tensions in the West Philippine Sea. Welcome to our program, Morning Matters, where we talk about the issues you need to know for the rest of your day. Now, first on the agenda, the Supreme Court has denied with finality the House motion seeking to revive the impeachment case against Vice President Sara Duterte, reaffirming its earlier ruling that the process was unconstitutional. Here's a report.
The Supreme Court en banc denied with finality the motion for reconsideration filed by the House of Representatives.
The Supreme Court has upheld its decision declaring unconstitutional the articles of impeachment against Vice President Sara Duterte. The magistrates were unanimous in denying the motion for reconsideration filed by the House of Representatives seeking to reverse the ruling. In July 2025, the Supreme Court declared the impeachment against Vice President Sara unconstitutional, saying it violated the one-year bar rule. Earlier, 3 impeachment complaints were filed against the Vice President between December 20 and 24 over alleged anomalies in her confidential funds. A 4th impeachment complaint was later approved by more than one-third of the members of the House and transmitted to the Senate on February 5, 2025. According to the Supreme Court, the first 3 impeachment complaints were not included in the order of business within the required 10 session days.
A session day for purposes of Article 11 in the Constitution was given its plain and ordinary sense, which the Court interprets to mean a calendar day in which the House of Representatives holds a plenary session.
The Court also reiterated that due process must be observed in impeachment proceedings. With the motion for reconsideration denied with finality, the ruling can no longer be appealed. The defense team of Vice President Sara thanked the Court for its decision. They said that with the issue now settled, the matter should be considered close, and the country should move on to address other pressing concerns. Meanwhile, the Makabayan Bloc, which earlier endorsed the impeachment complaint against Vice President Sara, maintains that the issues or grounds raised in the impeachment complaint remain valid and should undergo proper constitutional process. The Vice President was earlier sought to be impeached for alleged culpable violation of the Constitution, betrayal of public trust, and other high crimes. Related to this, the Makabayan Bloc is now preparing to refile an impeachment complaint against Vice President Sara. A complaint may be filed starting February 6 after the lapse of the one-year bar rule.
Former Congressman Zaldy Co was in Stockholm, Sweden earlier this month. That's based on court documents. Here's the report.
The Supreme Court has published the petition filed by former Ako Bicol Party List Representative Zaldy Co against the Office of the Ombudsman. Documents indicate that on January 15, Co was in Stockholm, Sweden. That's according to his notarized records from the municipality of Nacka. Interior Secretary John Vic Remulla said Co may be using a foreign passport, allowing him to travel freely across several European countries. The challenge of the Philippine authorities is that they still need a copy of Co's foreign passport before Interpol can act. Obtaining it requires coordination with the Portuguese government.
Kinukuha namin yung copy ng passport and then we're going to put it through Interpol na para hindi na siya makalabas ng Portugal at kung lumabas man, mahuli natin.
Despite his frozen assets in the Philippines, authorities say Co allegedly smuggled millions of pesos abroad using cryptocurrency. These funds may be sustaining his life while hiding overseas.
Criminal talaga. Marunong talaga sa krimen. Pati escape route ng pera, escape route ng bahay niya, kung saan siya titira, alam niya. Escape route ng pera, meron siya. More than a congressman, more than a businessman, he was a criminal.
At present, Remulla believes Co is in Lisbon, Portugal, and is under continuous monitoring by an intelligence team. If Co wishes to negotiate with the Philippine government, he must first return over 58 billion pesos, approximately $1 billion allegedly taken from the public.
Kasi ninako niya sa tao yun eh. Dapat ibalik natin sa tao.
The Philippines is also coordinating with Sweden to track Co's possible location. While President Bongbong Marcos remains determined to apprehend fugitives and bring them home to face justice.
Hindi natin masasabing may frustration ng Pangulo dahil alam po niya na ang mga namumuno sa mga ahensya ng gobyerno na tumutugis sa mga fugitive ay nagtatrabaho ng ayon sa kanyang utos. Kinakailangan lang po siguro talagang mas pursigihin pa ang paghahanap sa mga taong nagtatago sa kamay ng batas.
In other news, Senator Amy Marcos will be replaced as chairperson of the Senate Committee on Foreign Relations. Senate President Pro Tempore Panfilo Lacson confirmed that Senator Erwin Tulfo is set to take over the post, while Senator Marcos is being offered the chairmanship of the Committee on Constitutional Amendments and Revision of Codes. Lacson said Marcos had already been informed of the change by Senate Majority Leader Juan Miguel Zubiri. He explained that the majority has the first option to choose committee chairmanships, and as a gesture of goodwill, Senator Kiko Pangilinan agreed to relinquish the chairmanship of the Committee on Constitutional Amendments and Revision of Codes. It is now up to Senator Marcos if she accepts or declines the post. A strong majority of Filipinos continue to distrust China, with nearly 8 in 10 identifying it as the country's greatest external threat. That's according to a recent survey by Okta Research. The poll conducted from December 3 to 11 found that 60% of respondents were either strongly or somewhat distrustful of China. Only 13% said they trust China, while 26% remained undecided. Meanwhile, about 79% of adult Filipinos see China as the greatest threat, up from 74% in July last year. In an interview with A Big Story, Okta Research President Professor Ranjit Rai said public sentiment favors addressing tensions in the West Philippine Sea through diplomatic engagement, supported by a credible military presence and the continued modernization of the armed forces of the Philippines.
The majority of the Filipinos see West Philippine Sea as a serious issue. Majority of Filipinos think, number one, that we have to assert our rights in the West Philippine Sea, but we have to assert it, again, a majority in our surveys also say that we have to use the first step, which is to exhaust all diplomatic means.
Coming right up, the legal team of former President Rodrigo Duterte has filed notice before the ICC Appeals Chamber to challenge the January 26 ruling declaring Duterte fit to stand trial. We'll discuss that and more when ICC-accredited lawyer attorney Gilbert Andres when Morning Matters returns after a quick break. Keep it here on One News. Welcome back to Watching Morning Matters here on One News. The defense of former President Rodrigo Duterte has filed an appeal with the International Criminal Court challenging a recent decision denying his release from pre-trial detention. Duterte's camp argued that the court erred in refusing to consider medical reports from a neurologist and a neuropsychologist, which point to deteriorating health and cognitive impairment. They claim this decision violates Duterte's right to a fair hearing and have renewed their call for his immediate interim release. The ICC has scheduled former President Duterte's confirmation of charges hearing from February 23 to 27. And joining us now, we have ICC-accredited lawyer attorney Gilbert Andres. Magandang umaga sa inyo. Welcome back to the show.
Good morning, Gretchen.
You have officially been recognized along with Attorney Joel Butuyan as representatives to the drug war victims to the ICC. How does this change your role or elevate it? How do we call you now?
Just call me Attorney Gilbert. That's all right already. It means, Gretchen, that we are the official common legal representatives for victims, and we're the ones who are authorized to appear before the pretrial chamber for purposes of the confirmation of charges hearing. So we'll be the ones who will represent the victims, aside from one other lawyer from the Office of the Public Counsel for Victims.
Okay, so this designation is only until the confirmation of charges hearing for now.
Well, for now, and I think if it will move on, I think it will still continue on.
What happens, did the attorney Cristina Conti apply also? Bakit dalawa lang?
It's because number one has to be a part of the ICC list of counsel, and then number two is that there's also a consultation with other victims groups. So this is actually the result of. But just to be clear, we're part of the team. So there's a Philippine-based.
Attorney, medyo choppy lang, no? So hindi ko kayo maintindihan ng konti. So I think we should fix the signal a bit. We'll get back to you in a short while. Keep it here on Morning Matters. We'll take a quick break. Welcome back. You're still watching Morning Matters. We have on the show ICC accredited lawyer attorney Gilbert Andres. Welcome back. We hope the line is clear now.
Good morning again, Gretchen.
There you go, better. Okay, so my question to you is, bakit dalawa lang yung napili nila to represent the victims? Why is attorney Cristina Conti not part of those representing the victims?
When it comes kasi to representing the victims, one should be a part of the ICC list of counsel. And then secondly, actually, we're a team, Gretchen. So there's a Philippine team, and it has been agreed upon by the various victims groups in consultation also with all of the human rights NGOs and victims groups who have been helping in the Philippine war on drugs victims.
Oo. But isn't attorney Conti ICC part of the ICC list of counsel?
Okay, I think she's part of the assistant list of assistant to counsels.
Okay. Okay, that's clear now. And yung Philippine team, kayo yung napili, kayong dalawa. Ni Attorney Joel Butuyan.
And
Okay.
pinagagawa naman ng mga various victims groups.
How many victims are you representing now officially?
Okay, now if you look at the January 26 decision on victim participation, mayroon kasing ABC, di ba, na protocol, yung registry. Yung A, yung talagang siguradong pasok sila within the scope document containing charges. So under that, may at least 29 victim individuals. Tapos, meron naman sa Type C yung dapat pang desisyon na ng pretrial chamber. So, hindi nakalagay yung eksaktong numero, pero meron doon mga criteria. So, as of now, at least 29, but it's more than 29 kasi meron pang ang Type C na naaprubahan ng pretrial chamber na mag-participate po.
But some victim applications were rejected. Is it a matter mainly of scope that falls under yun nga do sa Group A, Group B, Group C, yung which refers to, I think, tama ba na yung time period of the former president as mayor, as president? What was the defining factor in the acceptance of the applications from the victims?
Okay, tama ka dyan, Gretchen. Yun naman yung nasa Group B, yun po talaga yung klarong nasa labas po sila ng scope ng document containing charges. Ibig sabihin, baka po labas sila ng time period kasi kino-consider lang po ng Office of the Prosecutor ay mga crimes against humanity for murder na nangyari po between November 1, 2011 hanggang March 16, 2019. So kung labas po ng scope na to, let's say nangyari po noong year 2021 or 2022, talagang hindi po siya pasok dun sa scope ng document containing charges at hindi po sila ma-approve sa kanilang victim application.
But for the Group B, which are victims outside that scope from 2011 to 2019, tinanggap po sila on the basis of what?
Pwede naman kasi mag-apply, oo. So, pero nasa sa pretrial chamber po yun, whether or not i-aprubahan po. So, nag-apply po sila, pero yun, fortunately, nasa labas po sila ng scope kaya hindi na po pinayagan ng chamber. At yun din po yung recommendation ng registry.
So is it correct that there are about 35 victims that you're representing?
Well, I think mag-iiba pa yung number, hindi pa siya definite, Gretchen. Kasi yun kailangan pang i-finalize. Kasi ang binigay lang talaga ng registry dun sa type C, for example, merong sample space, may sample na applications. Pero ipapasok pa yung the rest of the applications sa type C. At yung criteria, binigay po ng pretrial chamber last January 26 decision.
And what will their role be? Is this the final list of victims? Yung sinabi po ninyo, yung iilan kung saan ipapasok, may chance pang humabol yung iba to if they want to apply in other parts of the trial process?
Yes, mayroon pang chance, Gretchen. In fact, sinabi po yan ng pretrial chamber sa decision po nito last January 26 na if ever matuloy po sa trial proper at magkaroon po ng another phase, pwede naman pong mag-apply pa yung iba pa pong mga biktima ng war on drugs na gusto pong mag-apply. So, ito ay sa pretrial proceedings lang muna. In fact, yung OPCV po nag-apply na magkaroon ulit ng application period. Ngunit sabi po ng pretrial chamber, baka po lalo pang ma-delay kaya itutuloy na po sa February 23 yung confirmation of charges hearing.
And the initial set of victims, what will their role be?
So yung role po ng mga victim participants na naaprubahan po, ibig sabihin sila po yung na-recognize na victims dun sa within the scope as of now sa pretrial proceedings. So yung kanila pong mga suffered harm, yung po yung ipapakita po namin dun sa confirmation of charges hearing, yung mga damages at mga suffered harm, whether physical, psychological, emotional, intergenerational, yun pong ipapakita po namin at i-argue din po namin yung iba pong mga grounds na dapat pong ituloy po sa trial proper.
Will any one of them appear at the confirmation of charges hearing?
Okay, wala po talagang requirement na magkaroon ng in-person presence ang any of the victims kasi alam po ng chambers na talagang may heightened security risk ang mga victims kasi yung context dito ay ang charge crime, international crime. Kaya hindi po nila ni-require yun, kaya po nagtalaga po sila ng common legal representative for victims para po i-represent po talaga ang mga hinaing po at mga concerns at views po ng mga victims before the chamber.
I know this is, I'm not sure if this is within your jurisdiction, but Reina Garma was rumored to be testifying against the former president at the ICC to serve as witness. Could you confirm that with us?
But tipo sa mga bagay na yan, it's really sa Office of the Prosecutor, as now talagang hindi po talaga clear. Oo. At alam mo, Gretchen, when it comes to confirmation of charges, talagang it's very rare na mayroong in-person live witness. Kasi talagang mga factual at legal arguments po yung sinasambit po dito. Kaya ang ma-expect po natin talaga mga references sa evidence, references po sa witness statements. Pero wag po muna nating i-expect na merong live in-person witnesses. Kasi mas ginagawa po yan sa trial proper.
Okay. So, what will happen now at the confirmation of charges hearing come February 23? What should the public expect to go down?
The public should expect na magkakaroon po ng mga argumento, factual at legal po. And the issue really is whether or not yung 3 counts against Mr. Duterte ay kukumpirmahin nga at whether or not maputuloy po ba ito sa trial proper. So merong count 1, count 2, count 3. So kahit isang count lang po ang ma-confirm, matutuloy po yan sa trial proper. So yun pong magiging issue po dun sa confirmation of charges hearing. Tapos, syempre, magsasalita muna ang prosecutor, bibigay po nila ang kanilang panig ng argument nila, bakit dapat ituloy sa trial proper, at magbibigay din ng period para po sa mga victims, ano po ba yung suffered harm ng mga victims ng war on drugs? Siyempre, bibigyan din ng panig yung defense. Kaya makikita po natin dito yung interplay po nung dalawang partido, yung prosecutor at yung defense, at yung mga victim participants.
Pero dito, attorney, babasahan na lang ng desisyon ng pre-trial chamber kung confirm na yung charges or ito ay balitaktakan pa, debate?
Okay, so merong it will be for 4 days. So Monday, Tuesday, Thursday, Friday. Tapos kung wala nang mga further arguments or mga further presentations, mag-end sa Friday. Tapos magkakampo ng period at meron pong after that period na pinag-aaralan ng pre-trial chamber anong magiging decision, mag-i-issue po ito ng tinatawag na decision on the confirmation of charges. So dito po ipapalagay ng chamber kung meron ngang na-confirm mga charges, whether count 1, count 2, or count 3, or all of it, or some of it. Tapos ano ba talaga yung 4 na kwadrado ng confirmed charges against kay Mr. Duterte kung yun po naging decision ng chamber. So yun po I think more or less 60 days, if I'm not mistaken.
The decision will come out after 60 days, after the 4 days that you talked about.
Yes.
Okay. That's clear about what to expect. Now, will the surrounding issues be tackled here? When I talk about surrounding issues, ito pong issue tungkol sa kanyang kalusugan, tungkol sa kanyang interim release, at tungkol sa jurisdiction ng ICC. Do we expect that to be brought up in the confirmation of charges hearing, or will those be settled outside the confirmation of charges hearing?
Okay, doon po sa health, actually na-decide na po yan, magkaroon nga ng 3-person expert panel report. At na-decision na ng pre-trial chamber na fit to participate in the pre-trial proceedings si Mr. Duterte. At mayroon ding mga measures para po sa kanya, kaya Gretchen, hindi tuloy-tuloy, yung hearing. After 1 hour ng hearing, may break po. So, chinank po ng pre-trial chamber at meron ding break in between the week. Kaya Wednesday po, wala pong confirmation of charges hearing. So, may mga measures na po na placed ng chambers po. Ikalawa po, doon naman sa issue ng jurisdiction, hindi po ito itatapol kasi it's before the appeals chamber. Number 3 po, patungkol naman po sa interim release, actually mayroong provision for a automatic review at least once a year. At sinama na rin po yung issue na yan, yung review ng detention, continued detention ni Mr. Duterte. Sinama na po yan dun sa confirmation of charges hearing. In fact, I think it will be on the Friday, February 27. Yan po ang itatakol po sa remaining hours pong yun ng Friday, Feb 27. Yung review ng continued detention ni Mr. Duterte.
Now, I wanted to ask you about that because I do remember that this is subject to a periodic review every 90 days, if I remember correctly, yung kanyang continued detention and interim release request. Thus, the decision on fitness to stand trial affect that decision kasi ang sinasabi ngayon ng defense ay hindi na consider yung kanilang medical report, which I remember we were talking about it is new evidence that the ICC pre-trial chamber is required to look at in the assessment of the interim release request. Anong ibig sabihin nun? Kapag dineclare nilang fit to stand trial, yun din ba ay decision na on the new medical evidence that's provided?
Okay, as syempre, i-separate natin yung issue ng health, tsaka yung interim release, Now, doon naman sa ni-raise ng defense, it's actually with respect sa decision on the fitness to participate. Oo. So, in fact, meron pong three-person expert panel, yan po naging basis ng decision ng pretrial chamber. Kasi meron naman talagang power and authority yung pretrial chamber na mag-appoint ng independent, competent, and ng sarili nilang expert panel. So wala po talagang command sa pretrial chamber, walang statutory provision na dapat i-consider niya yung mga sinabmit ng report, whether ng prosecutor or ng defense, kasi pwede po talaga magtalaga ng sarili nitong independent expert panel sa fitness to stand trial. Now, yung issue kasi ng interim release, separate siya sa fitness to stand trial. So, doon po sa issue ng review ng continued detention, I think hindi po dapat doon ihahalo yung issue sa fitness to stand trial kasi na-decision na po yan ng chamber.
So kumbaga parang the defense was merging the two, trying to use the health argument to gain an interim release for the former president. Kaya po napagsasama na rin ho natin. Pero iba po ito.
Yan, actually,
Walang bearing, wala bang bearing? Sa bagay na-declare na siyang fit to stand trial. So what would be the possible grounds for the granting of an interim release at this point?
Actually, titingnan pa rin yung three factors for an arrest warrant, which is also the three factors for the continued detention. Flight risk ba yung yan? Continuing flight risk po ba siya? Number two, makaka-apekto po ba siya sa investigation at proceedings? At number three, makakagawa pa ba siya ng krimen na chinarge sa kanya? So, yun pa rin yung tatlong factors na yun, dun pa rin mag-revolve yung magiging consideration ng chamber sa review niya.
Okay, and after the confirmation of charges hearing, when would we expect things to go to the trial phase?
Okay, it's a big if, Oo, kasi in fact yan yung magiging decision ng pretrial chambers. Hindi ko pangunahan yung pretrial chamber. But siguro ang dapat nating alamin ano bang kailangan ng ebidensya. Oo. Para po sabihin ng pretrial chamber, ay tuloy na to sa trial proper. Hindi po kailangan ng proof beyond reasonable doubt kasi sa trial proper po yan. Pretrial pa lang po. Ang kailangan lang po sufficient evidence to show that there are ito technical term po to, substantial grounds to believe that the suspect committed the crime. Kaya nga po, rare po yung in-person na mga witnesses kasi mababa lang po yung yung quantum of evidence na tinatawag, substantial grounds to believe lang po.
Well, crucial next days to come. We wish you good luck in your role as the official listed counsel to the victims. Thank you so much for your time on this Friday morning. We have ICC accredited lawyer attorney Gilbert Andres. Up next, we're circling back to our top story for this morning. The Supreme Court has denied with finality the House motion seeking to revive the impeachment case against Vice President Sara Duterte. Retired Associate Justice Adolfo Ascuna Jr. weighs in on the decision. When Morning Matters returns, keep it here in One News. Good morning, I'm Gretchen Ho, and here on Morning Matters, we talk about the most pressing issues and give you the context behind the headlines. As we know, the impeachment case against Vice President Sara Duterte filed last year is now effectively closed. The Supreme Court has denied with finality the motion filed by the House of Representatives, standing by its earlier ruling that the impeachment violated the Constitution's one-year bar rule. The High Court said the required procedures were not followed, stressing the need for due process in impeachment proceedings. While the Office of the Vice President welcomed the decision and called the matter settled, groups backing the impeachment maintained that the issues remain valid and say they are preparing to refile once the one-year ban lapses. Joining us now on the show, we have Adolfo Ascuna Jr., retired Associate Justice of the Supreme Court and a respected constitutional law expert. Magandang umaga. Welcome back to the show. Justice, can you hear us? There you go.
Good morning.
Okay. Justice, the Supreme Court again unanimously upheld its earlier decision on the Duterte impeachment complaint. What was your immediate reaction to that decision? Does the upholding and the voting come as any surprise to you? 13-0, denying with finality the Vice President's impeachment complaint.
Yes, ang ibig sabihin yan na resolusyon ng ating Korte Suprema na pinalabas kahapon ay final na talaga yung kanilang desisyon na binasura yung articles of impeachment na inadopt ng ating lower house noong February 5, 2025. Dahil void daw yun dahil labag sa one-year ban. Yun po ang kabuuan ng resolution na yan. Ngunit maraming pinaliwanag na dinagdag ang Korte Suprema sa mismong resolusyon na ginawa kahapon.
Kayo po ba ay nagulat dito sa desisyon o inasahan po ninyo?
Hindi naman ako nagulat dahil medyo expected ko na yun na di-deny talaga nila yun. At saka expected ko rin na magpapaliwanag sila sa ilang puntos na dapat liwanagin doon sa desisyon na yon.
So yung main issue po dito, yung naging pag-upo doon sa first three complaints bago po ito ini-refer sa Committee on Justice. Tama po ba?
Tama, yun po ang bagong issue na nagdagdag sila ng tinatawag na another way of initiating impeachment proceedings aside from referring it to a committee ay kung uupuan lang daw at lumampas na yung takdang panahon na pag-refer sa committee ay yun ay initiated na rin.
Ibig sabihin ho, nagbabago na ho yung definition ng initiation with this new ruling?
Hindi naman binago yun. Dating definition, dinagdagan lang. Sa Supreme Court decision ngayon, meron ng karagdagan na dalawa pang paraan kung paano mag-initiate ng impeachment proceedings. Ang una, yung dati, good pa rin yun. Namely, referring to a committee after receiving the complaint and calendaring it within 10 days, referring it to committee within 3 days. Good pa rin yun. Initiation pa rin yun. Ngunit pag hindi ito ginawa sa takdang panahon 10 plus 3 days at binago nila yung definition ng days na yun, that is calendar days during which Congress is in session, kung pagtanggap ng complaint, lumipas na yung 10 days pag-calendar at 3 days pang-repair na hindi naman kinalandar, hindi rin repair sa committee, ay yun paraan na rin na tinatawag nilang initiating na rin yun. That is the second type of initiation that is added by the Supreme Court in this case. There's a third type pa. Kung kahit na hindi lumampas yung takdang panahon na yun, pero nag-adjourn sila, nag-adjourn na hindi pa rin refer sa committee pa rin, ayun na initiated na rin.
So as a framer of the Constitution, do you think this upholds the spirit of the law?
Ang nasa Constitution kasi nakalagay na oras na merong tinanggap na balido na tamang complaint, ibig sabihin under oath. Tapos kung galing sa isang mamamayan, kailangan endorse ng member ng lower house. O kaya originally verified, filed by a member of the house, yan ang duly filed complaint. Ito dapat within 10 days from the filing, ilagay sa kalendaryo ng plenary. And within 3 days na nalagay sa kalendaryo, i-refer sa Committee on Justice. Ngayon, unang binago ng Supreme Court yung definition ng 10 days at 3 days. Hindi ito session days, kung hindi calendar days during which Congress is in session. So bagong konsepto yan. Pero ganun pa rin, meron po 10 days, 3 days. Kung hindi ito ginawa, hindi kinalendaryo, hindi refer sa committee, at lumampas na yung 10 days at 3 days na yon, ay yung complaint na yon, ibig sabihin na initiated na rin. Ano yun ang nangyari dito? Yung complaint na final, tatlo kasing final, merong December 12, December 16, December 24. Yung unang final, December 2, ay lumampas na yung 10 days, 3 days, hindi refer sa committee. So, sabi ng Supreme Court, na-initiated na yung proceedings by that first complaint. So when Congress adopted its own articles on February 5, 2025, pangalawa na yun. Barred na yun. Sabi na, pang-apat na nga, barred na by the first complaint which was not acted upon within the mandated period.
Pero nabanggit nyo rin ho, doon sa post nyo sa Facebook, that the articles approved by Congress on February 5 last year were not yet barred by the inaction on the 3 earlier complaints because the 10-day deadline has not yet lapsed, according to the House's interpretation of the constitutional time frame. So hindi po kayo agree sa desisyon?
Hindi. Sabi ng Supreme Court, kung sundin mo yung session days, hindi pa nag-lapse. Dahil yung session ng Kamara, ibang konsepto yon, maaaring several calendar days yun eh. Pero sabi ng Supreme Court, hindi dapat yun ang sundin. Dapat sundin yung plain meaning ng day, which is calendar day, during which nagsisesyon sila. So kung yun ang gagamitin, lumampas sa yung panahon.
Oo, para pong ito po yung naging usapan ng LTO tsaka ni James Deakin, yung calendar days, working days. Dito, the application is calendar days when Congress is in session or session days. So, medyo napapabilis po yung proseso. And speaking of that, what was your observation about the effect of that ruling to the whole impeachment process? If you take a look at the filings made against the president, dalawa lang ho yung natanggap nila nung unang session day, which was the complaint of lawyer Andre De Jesus and the complaint of the Makabayan Bloc. Okay lang ho ba yun na hindi po nila inantay na lumipas po yung 10 days na diniretso na kaagad po sa Committee on Justice, hindi na ho nakahabol kung sino man may gusto pa. What is the effect of this ruling on the whole impeachment process as an accountability tool?
Yung ginawa nila, tama po yun dahil within 10 days from receipt on filing of those two complaints against the President, na-refer nila kinalendaryo tapos refer doon sa Committee on Justice within that 10 days and 3-day period required as interpreted calendar days during which they were in session. So these two complaints which were initialized already together will bar any further complaint.
They have no requirement to let the 10 days pass, at least wait for others who intend to file. Hindi po ba magiging unahan na ho itong filing? Baga parang race against time?
Hindi naman, dahil pwede naman within 10 days from the time yung una na file, hintay nila kung meron pang darating. Pwede pa nilang tanggapin dahil they have 10 days to refer to the committee from the filing of the first one. So if there's a second, third, fourth filed within the 10-day period, maaari nilang isabay yun pag-refer sa committee, yung tatlo, rapat.
Pero kapag na-refer na ho sa Committee on Justice, hindi na po pwedeng umabol.
Hindi na. Pag meron nang na-refer sa committee, hindi na pwedeng humabol dahil initialized na yun eh. Na nag-kick in na yung 1-year ban.
But doesn't that make opportunity slimmer for others? At least a fair right to be heard kapag ganun ho?
They will have to wait 1 year.
Ano ho?
Yes. You have to wait next year.
Oo, yun nga ho. So, eto hong na mga gusto mag-file pa ng impeachment complaint laban sa Pangulo, what would their recourse be now? I know there are 2 complaints already that have yet to be tackled, but what other recourses do they have? Specifically, ito po kung wari ho, yung grupo nila Mike Defensor.
Anong recourse ng hindi nakahabol?
Oho, yes ho.
Well, they can participate in the hearing. It's open naman to the citizens. Hearing of the first 2 na na-file. And take part there. Kung they have evidence to present, they can also ask the committee to receive their evidence. Siguro gano'n na lang. Dahil yung mismong complaint nila, hindi na pwedeng i-file yun. Hindi na pwedeng initialize dahil barred na.
Okay. The Supreme Court also ruled that the doctrine of operative fact does not apply in this case. The spokesperson of the Supreme Court said that the operative fact doctrine cannot be invoked by the party directly responsible in the commission of an unconstitutional act. Do you agree with this assessment by the Supreme Court? Kasi ang argument ho ng Kongreso ay sinunod na nila yung Gutierrez versus House of Representatives on the definition of initiation. Ang sinasabi ng Supreme Court, hindi mag-apply yan kasi unconstitutional yung ginawa ninyo. Do you agree with that assessment?
Okay, ang issue doon is itong bagong definition ng Supreme Court ng dinagdagan yung paraan ng pag-initiate ng proceedings. Sabi ng Supreme Court, normally, kung binago yung definition, in this case, may bagong definition, hindi naman binaliwala yung former, pero nagdagdag ngayon ng another way. So, itong panibago, hindi dapat i-apply retroactively sa mga nangyari na hindi pa ginawa itong bagong definition. Yan ang rule of operative facts. Ngunit sabi ng Supreme Court, hindi i-apply ng rule ng operative facts sa sitwasyon dito dahil yung prinsipyo na yan maaari lamang gamitin ng isang party na hindi kasagwat sa paggawa ng paglabag ng batas. In other words, Congress cannot invoke it, the lower house cannot invoke it because it is in bad faith. Yun ang sinasabi ng Supreme Court.
And do you agree with that?
I agree with that. That is really the principle. And since Congress deliberately avoided the kicking in of the period by not acting on this complaint, that is bad faith. So, tama yung Supreme Court.
Dahil hindi ho gumalaw, kumbaga parang meron na dyang complaint, hindi mo inasikaso. So, bad faith.
That is,
But
yes.
your fellow CONCON delegate, Attorney Rene Sarmiento, called this decision judicial amendment to the Constitution and an overreach. He in fact says that the decision emasculates impeachment as a weapon of accountability as envisioned by the framers of the Constitution. Ano po masasabi po ninyo dito sa naging opinion ni Attorney Rene Sarmiento?
Sa palagay ko, tama rin si Attorney Delegate Rene Sarmiento kasi binago ng Supreme Court, sinabi na nga ng saligang batas session days. Bakit sinabi ng Supreme Court, ibig sabihin yan, calendar days. Panibago na yan. So, but then, the Constitution is what the Supreme Court says it is. So, kaya sundin natin yung definition ng Supreme Court dahil yun ang interpretation nila ng ating saligang batas.
So is there, could the Congress choose not to follow the Supreme Court ruling if they decide to? Because curiously, the Supreme Court also reemphasizes that Congress is granted the sole prerogative to define the rules on impeachment. So if they choose to do so, pwede ba nilang hindi sundin itong ruling na ito?
Yes, this presents a problem because the Congress, under the Constitution, has the continuing power to frame and adopt rules to implement the impeachment provisions of the Constitution. So, supposing Congress now will adopt a new rule, but it will not follow the new definition of the Supreme Court. So, magkakabanggaan ngayon ang Congress at Supreme Court on the definition of 10 session days. So, ang mangyari yan babalik naman sa Supreme Court yung bagong kaso, questioning ngayon yung bagong role ng Congress na kung maaari ba ito nilang baguhin yung definition ng Supreme Court. That will be another issue, another case.
And we might end up in a constitutional crisis if that happens.
Yeah. Yes, that will be another test case because the definitions of the two political and constitutional bodies will be in conflict again.
Well, Justice, what other recourse is there now for those who see judicial overreach? The Supreme Court says there's no more room for appeal. How firm is that declaration?
Sa palagay ko, hindi naman mahirap sundin yung Supreme Court decision dahil maaari namang sundin lang yung Francisco ruling. Yung Francisco ruling, within 10 days, palagay mo na calendar days. Mas mabilis lang konti yan within 10 calendar days during which they are in session, i-calendar ka agad, ilagay sa calendar ng plenary yung complaint. And within 3 calendar days during which they are in session, i-refer ka agad sa committee. In which case, valid lahat yun. That is a valid way of initiating a complaint. So, hindi problema yun. Doon sa committee naman, they have 60 days, session days, calendar days during which they are in session to finish the hearing and make the report. So, 60 days, 60 calendar days. Sapat na yun Okay lang.
And speaking of test case, it is possible that we're going to get 2 impeachment complaints against the president and the vice president. How do you think that would go? I mean, you as a framer of the Constitution, that will also be tested. That will also test, I guess, the principal function of government. Magiging tried po yung top 2 officials of the land. What are your thoughts on that and the stability of Philippine governance?
Yes, kaya po nilimit ng ating saligang batas yung frequency ng pag-initiate ng impeachment proceedings laban sa high officials is in order not to take them away too much from their primary duty as government officials. Kaya maaari pong sabay mayroong pinile na impeachment complaint against both the President and Vice President. It's up to Congress, the lower house, on how to prioritize kung sinong unahin nila dito. That is up to them. However, it is subject to the time frames under the Constitution. They have to resolve, the committee has to resolve the complaint, make the report within 60 session days. Ang ibig sabihin ngayon ng session days, calendar days during which Congress is in session. So, merong limit eh. They have to act within those 60 days, file the report to the plenary together with the resolution, draft resolution of the articles, or draft resolution denying the complaint.
I guess as a final point, beyond all the legal jargon, do you think that it is now much more complex and difficult to actually use impeachment as an accountability tool?
Under the original decision of the Supreme Court, bago ginawa itong resolution kahapon, it is very difficult because it requires that each and every member of the lower house be proven to have read and understood the complaint, to have studied and understood the evidence. Tinanggal ho yun. Wala na ho yung requirement na yun. In fact, if the Congress, if the lower house adopts the second mode of filing a complaint, that is a verified complaint is signed by at least 1/3 of the members of the House. Dati sinabi, kailangan magkaroon ng hearing yung buong mababang kamara. Ngayon hindi na. Hearing will be by the committee only if Congress wants. Naging optional na yung hearing. So mas madali na rin.
Okay.
Hindi na imposible.
Okay. Maraming salamat. Thank you so much for helping us understand the latest Supreme Court decision. We have the author of Forthwith in the Constitution, retired Associate Justice Adolfo Ascuna Jr.
Thank you, Gretchen.
And that wraps up today's episode of Morning Matters. We hope we've given you the right start to your morning. Let's go ahead and make the day matter. My name is Gretchen Ho. Kapatid, we are One News, all sides, all the time.